Hello, everyone. Thank you for joining us in today's session. We will be starting the proceedings shortly. All right, it's 12 o'clock. We can get started. Thank you so much for joining today's session on navigating green card delays. I'm joined alongside Prashanti Reddy. My name is Vishal, and I'm your moderator for today's session. Uh, a little about Prashanti. Prashanti is an award-winning immigration attorney specializing in immigration law. With over 25 years of experience, she is an extinguished and distinguished member of various associations, including American Immigration Lawyer Association and the New York Bar Association. She's currently admitted to the bar in New York, and Prashanti is actively involved in other forms of roles, including current advisor and immigration counsel for the Indian Consulate in New York, and is also actively involved in pro bono legal work as well. Prashanti has recognitions and achievements from industry bodies and others. Some of her recent recognitions include getting listed by Forbes as one of New York City's best immigration lawyers in 2024, amongst other recognitions. On that note, Prashanti, I invite you to take over and we can start with the latest immigration updates.
Absolutely, Vishal. Thank you for that introduction. Let's go to the first slide. I think we're going to be talking about the June visa bulletin in our update section. Not a lot has moved, especially for Indian nationals, in the June visa bulletin. Just to give you an idea as to what a visa bulletin is, every month the Department of State publishes a visa bulletin, and the visa bulletin will tell you what priority dates USCIS is working on, and if your priority date has been reached, that means you'll be able to file for adjustment of status if you're in the country, in the US, or if you're outside the country. If you're outside of the US, then you'll be most probably invited for be able to file an immigrant visa petition, and you'll be invited for an interview at the consulate abroad. So there are usually two tables in a visa bulletin, dates for filing table and final action date table. Final action date is the table that gives you the actual dates, whether it's available or not, your priority date. And the dates for filing is something that the Department of State introduced, and USCIS will give you an indication every month as to which table they're going to use. But the dates for filing table is a table where USCIS is allowing you to file your adjustment of status, your green card, in advance of the dates becoming available, because they're hoping that by the time you file and by the time they process your case, your priority dates will actually become available. So it's like an advance filing. And so usually the dates for filing dates will be ahead of the final action date. So having said that and explained that a little bit, and again, if you want to go and look at the visa bulletin, you can just type in, go to travel.gov and or just type in visa bulletin in your browser, and you should be able to get to the visa bulletin. The visa bulletin is usually given in advance. So the June visa bulletin was published in May, usually in the first or second week of May. So let's look at what happened in the visa bulletin for June. EB2 moved forward by 2 months for China. And for China, EB3 also advanced by 3 weeks. For India, there was no change at all in any EB category. All other countries, we see a slight forward movement. EB2 jumped ahead by 4 months. EB3 moved forward by 5 weeks. And as I was saying about the different tables, USCIS will be using the final action date table for the month of June. And we'll continue to use the final action date table for the rest of the year. So this, of course, we're only talking about employment based, but there is another, there are tables for family based cases as well. You can go to the next slide. Since today's webinar is about green card delays and why we have green card delays and how to overcome these delays, let's talk a little bit about processing times for various types of green cards. For a renewal of a green card, that is once you already have a green card, to get it renewed takes about 2 years. For immigrant petition for an I-130, it's taking if depending on what category, but to give you one example, US citizen filing for spouse, parent or child under 21 is taking about 17 months. 485 family based is taking about, I mean, this is again just an example because there's so many various permutations for this depending on where it's filed, what kind of case it is. So just to give you an example, family-based case that is presently in the field office in Brooklyn, New York, is taking about 2 years. If it, usually a family-based case doesn't get filed in Brooklyn. 485 gets filed in the service center, and service centers are usually taking about 12 to 18 months. So when you look at the next column for 485 employment based, all field offices, it's about 12.5 months. So that's the same for family based cases also, it's taking around that time. But if the case goes for an interview to the field office, such as in Brooklyn, New York, then it can take longer. Fiancé visas, this is when you're not married, but you're filing for your fiancé. That's taking about 9 months at the California Service Center. Again, it changes depending on the service center that you have to file at. I-140, that's the immigrant petition. 485 is adjustment of status. So that's the third step in a green card application. I-140s and I-130s is the immigrant petition. That's the second step, or sometimes the first step, depending on the type of green card that we're filing. And again, if we have time, we'll go through the entire process of how to file a green card as well, and then it'll become clearer to you as to what an I-130 is and what I-140 is. So I-140 for employment-based cases is taking about 14 months. But of course, an I-140 also has premium processing. So if you opt for premium processing, it's taking about 30 days. For premium processing, of course, there is an additional fee. And we also put in naturalization here, though that's not a green card. Citizenship cases are taking about 9 months. Again, this is in, just to give you an example, in Brooklyn, New York. So in general, if the date is current, and if you're filing an I-140 and 485 or I-130 and 485, I-130 is family-based, I-140 is employment-based. And if you're filing the immigrant petition and the adjustment of status together, you can expect, and if your date is current and continues to be current, you can expect that you'll get your green card in about 12 to 18 months. We can go to the next slide now. Let's talk about some common reasons for why green cards get delayed. And we talked about visa bulletins. Let's talk about why that can cause a delay. In our immigration update, we talked about the June visa bulletin. So let's see why visa bulletin retrogression causes delay. And this is the major reason for delay. And if you especially look at Indian nationals, there are thousands of applications pending because there's no visa numbers available. So what is a visa number? Every year, Department of State issues about 140,000 immigrant green cards. So there is a set number of green cards that can be issued every year. It's not unlimited. And so people from all countries, all categories have to stay in line to, get a shot at getting a green card that particular year. So that creates a backlog, and therefore we have a visa bulletin which has priority dates in there, and the date is the date that you filed either your immigrant visa petition, which is the I-140 or I-130, or if you're filing under an EB2 employment-based category, 2 and 3, it could be the labor cert. It could be the date that you filed your labor cert. So that's your priority date. So the priority date, your dates, if you look at the visa bulletin, well, you can see that there's a backlog in most categories except for EB1 worldwide. EB2 and EB3 are backlogged for most countries. And family-based cases are also backlogged. There is no backlog only for family-based immediate relatives. That is, if you're U.S. citizen filing for your children, spouse, or parents, there's no backlog for that because it's an unlimited number of green cards that are issued for immediate relatives. There's only a limit on the number of green cards for the other categories. So as you can see, if you belong to one of those other categories, either employment-based or family-based, then there will be retrogression because there's only a limited number of green cards issued every year. And there is heavy retrogression, especially for EB2 employment-based categories. So people with a master's degrees is EB2, people with bachelor's degrees is EB3. And so there is a backlog for EB2 and EB3 India as well as China. And because of this, you might have filed your green card while your priority date was current, but while your 485 was being adjudicated, the priority date might have retrogressed because the priority date keeps changing every month. So this will put your green card petition, your 485 adjustment of status petition really on hold until the visa number becomes available again. And this could result in a delay of months or sometimes even years. So that's the major cause for visa bulletin retrogression is the major cause for delay in green card processing. The next reason is USCIS backlogs and backlogs at the consulate. That is another reason for delays in green card processing. Again, USCIS as well as visa backlog. So if you're outside the country, the backlog might be at the consulate because they might take some time to call you for interview, some time to process your case. So all these backlogs are as a result of staff shortage and funding shortage. And there's also another reason is increased application volumes. Also, certain events that occurred, such as COVID, the pandemic caused, shutdowns for several months of, at USCIS as well as at the consulate. And so, cases got backlogged. And so we saw post-COVID that there were huge backlogs at the consulate and as well as at USCIS. Also, because applicants have to be scheduled for biometrics appointments, they have to be scheduled for interviews at USCIS and also at the consulate, depending on where they are. That can cause delays as well because these things have to be done by, can't be automated and they have to be done by in person. The third reason for delays could be that you received a request for evidence, an RFE. You submitted a petition, a 485, they were not happy with the documents you submitted and they asked for additional documents. This will cause delay in your application because now it will be taken out from the regular uh, process and it'll be put in the RFP line. So it takes time for them to send you an RFP, and then it takes time for you to respond to the RFP. And then once you respond to it, it also takes time for them to review the RFP and move forward. Why do they usually send RFPs? It's usually for incomplete or inconsistent documentation, uh, maybe missing translations or evaluations, ambiguous documents, ambiguous educational records, immigration history, etc., etc. So failure to um, document your case properly could lead to delays in processing of your case. An RFE usually is allotted 87 days for you to respond. So some people take the entire 87 days to respond because maybe they don't have documents immediately available. Maybe they have to get those documents such as a birth certificate, etc., or a non-availability certificate if the birth certificate was never registered. That takes time. So usually, sometimes people take the entire 87 days to respond. Another big reason, um, I'm sorry, I'm not telling you to move the slides, Vishal.
Yeah, I'm not moving.
I'm going to the
The,
reasons. I'm sorry
the
about that.
reason. Okay, yeah, no worries. Yeah, I just want to make sure.
Uh, where are you at? Let me check. Sorry about
Yeah, no worries.
that. I talked about, I'm at number 4. Actually, I talked about RFEs, request for.
Yep. So here, we were still talking about like RFEs was done.
Okay, okay.
Yeah,
Because I noticed that I didn't say move the slide. Sorry about
yeah,
that.
yeah, no worries.
So the next one is the security clearance
Yeah.
and background checks. That's another reason for delays. Any case before it gets approved has to be vetted. There's several security checks that have to be done, and these are done by multiple agencies. DHS does it, FBI does it. There are several types of security clearances, such as name checks, fingerprint analysis, FBI checks, criminal record checks, background investigations. And this sometimes causes delays because your case might get stuck in an FBI name check. And this could be because you have a common name with someone else who's on the FBI list, and they have to make sure that you're not that person. So sometimes it takes time, and they do extended vetting if you have a name that's common. So that's something that we have seen as well. Also, sometimes security checks happen outside the country if you're outside the country at the consulate level, and this also leads to severe delays. Sometimes the delays are can be for a year, 2 years, 3 years, even sometimes. And usually, nothing you can do about this except maybe file a lawsuit in a federal court, asking the USCIS to process your case in a timely manner. Nothing else works because once they put the title of security check, then nothing else seems to work to bring it out of that security check. It has to take its time. The next is the medical exam. Could be a reason why you face delays. Medical exam is again I-693 form has to be submitted for all green card applications, and the I-693 form has to be completed and authorized by civil surgeon to show that you're not inadmissible due to some public health grounds. Usually, medical exams will expire in a year. USCIS keeps changing that. Sometimes they say a year, sometimes they say 2 years. And sometimes they send RFPs even for medical exams that are a year old or less than a year old because, especially during the pandemic, they wanted you to get COVID vaccines. So if they see that there's no COVID vaccine, they might send you an RFE for a medical exam, and that could cause delays. And sometimes you might send everything, but maybe the document was not filled out correctly, or there was some missing vaccinations. Maybe the form was not signed by the civil surgeon, um, or maybe the additional tests were not done. Sometimes if they find you, if the report says that you're positive for, say, TB, you have to then get an additional X-ray done to show that you presently don't have uh, TB. So that can cause delays or um, lead to requests for further evidence. I think now you can go to the next slide. Errors in filing is a very common reason for delays in your green card application. Mistakes in the application process, including mistakes in form preparation, payment submission, all could lead to your entire case coming back, and the case doesn't really come back immediately. It takes a couple of months, so that could cause delays, and that could lead to your window of opportunity to file to be closed, because maybe the visa number now, if the priority date is not available, and it was when you actually filed it. So missing some common errors include missing or incorrect signatures, sending wrong filing fees, or you send a check which is not signed or not dated, or maybe the check is not written properly. Maybe you're sending outdated forms because USCIS keeps updating their forms, and then they don't allow you to send the old forms. They'll reject it if you send outdated forms. But if you send it to the wrong address also, that can cause USCIS to send your case back. And as I said, this again extends the overall timeline as you will be required to refile it. Family derivative cases. Sometimes, your child might age out because the processing time uh, takes some time. USCIS, as I said, we looked at the several reasons why green card cases have prolonged processing times. During that time, your child might age out because your child has to be under 21, or maybe your child now gets married. And so then that you become eligible for a different category. You won't be in the category that you filed under. And because of that, there might be delays because, again, the visa number might become unavailable for you. You might move from a immediate relative category to a category which now has a limited number of green cards available every year. Also, children may age out if they turn 21, as I was saying. And if that happens, um, unless you're covered under the CSPA, Child Status Protection Act, again, that might cause delays. But even showing that you're covered under CSPA involves additional work, and that itself might cause delays in order to prove that you are covered under that particular um, law. And as I was saying, changes in location, changes in immigration status, so many things can change. All that can cause delays. So also, missing deadlines can cause delays, um, and separation in families. So there are a lot of things. Poor coordination can cause delays. Another reason for delay is policy changes. We're seeing under the present administration that changes keep happening, every day really, with reference to policy. So we can expect in the immigration field also that there will be changes in policy, constant changes in policy under the present administration. As it is, immigration is fraught with constant changes. USCIS changes the way they process cases. So there doesn't have to be a change in the actual law to cause delays. It could just be change in the way USCIS is processing cases. And that changes depending on which administration comes in or what the present politics are. So, one important change, for example, is the change to the public charge rule. And this has caused delays in green card processing in the past, and it might cause those delays again moving forward as well. So, under the previous Trump administration, they changed the public charge rule. Public charge is basically USCIS has to, before approving a green card, make sure that you will not be a public charge, meaning that you will not be dependent on the government for sustenance, for food, for shelter, etc. So, what comes under public charge? Who comes under a public charge? Who is considered to be likely to be a public charge? That keeps changing. So, as I said, that can cause delays as well. Also, certain things like work authorization for H4 spouses, DACA renewals, all these things can cause delays in green card applications. Also, when as administration changes the laws, people file litigation to stop them from changing it or prevent them from changing it. So when those cases are in court, that also delays implementation of the new rules and maybe implementation, and that causes delay for your application as well. So what's the impact of this? Pending applications, green card applications may have to be re-adjudicated under new criteria. Applicants may be required to submit additional documents or maybe restart portions of their green card process. So this kind of legal uncertainty creates unpredictability in planning timelines for both families as well as in employment based cases as well. I think with that we're done with that section.
Yes, and before we move to the next slide, I would just like to remind everyone that we will be taking questions. Prashanti will be taking questions by the end of the presentation. And I already see questions coming in from YouTube as well as some live streamers. So irrespective of where you are consuming this information, whether you're streaming through YouTube, LinkedIn, Facebook, or you streaming directly, you will have opportunity to drop in your question. I do recommend dropping your question as soon as possible. And I also suggest dropping your question in one single text so that it will be easier for us to take your questions once Prashanti is done with her presentation.
So shall we take the questions first and then continue with how would you like to do it?
Yes, I was thinking the same, Prashanti, because some of these information, some of the questions, I think, is what people are interested in asking. So we might well just go through the questions first, and then if we have time, we can come back to the presentation.
Sure, let's do that.
Okay.
Since we did cover our main topic, which is navigating green cards, and the rest of our presentation is about the process. So we could always come back to that when we have time.
Sounds good. So this one is from YouTube. Harsimran Preet Kaur is asking, there are three or four texts. I'll read one by one. When can we expect our interview?
I think they're all related, so I think you have to read all of them.
Okay, so I'll just go through all of them. When can we expect our interview? Priority date is June 21st, 2006. Document qualified date 30th December 2024. F4 India case. Yeah.
So you have to look at the visa bulletin, and I'm sure you're doing that, Harsimran Preet. Harsimran is asking when to expect their interview date to come in. This really will only happen once your priority date becomes current. And we know F4 priority dates for India are the most backlogged. And since your priority date is 2006, you have to wait for the priority date to become available. I haven't looked at priority dates where they are right now in the June visa bulletin, but you have to wait for your priority date to become available. Only when the priority date becomes available will the Mumbai consulate in India start processing the case. They'll start looking at the documents, asking you for you to get your police clearance certificate, to get your medicals done, and they will invite you for an interview only once the priority date becomes available. So please make sure you're looking at that visa bulletin every month and reach out to the consulate once your visa bulletin becomes available. Once the priority date becomes available in your visa bulletin.
All right. Next one is from Nana Mukin Krishnan. How often RFEs are being issued by USCIS while filing I-485 under current administration? How lawsuits will help applicants stuck with RFEs and delays? And are RFEs being issued for wet signatures?
How often are RFEs being issued? I don't see an increase in the number of RFEs being issued so far. With the present administration, it's pretty much the same because I don't see there's no this time the Trump administration has not implemented any new rules with reference to public charge as yet. I just think that they have not prioritized as yet, but we'll most probably see that in the future. So whoever is filing for a green card or wants to file for a green card, I would suggest you do it sooner rather than later because it's only downhill from here. Uh, so as while there's still status quo, I suggest that you file your green card because we don't know what to expect moving forward. And it's only going to get more stricter and there's going to be more vetting. But as of now, we don't see any changes in the processing. Neither do we see any changes in the processing time. But slowly we're seeing a less and less inclination to expedite processing and less and less inclination to um, give the benefit of doubt when there are instances where the case is borderline. So RFEs being issued, I don't see a higher volume of RFEs being issued. They're being issued the same as always. If there is an issue with the birth certificate, as I said, if there's any issue not filed properly, documents are not proper, maybe all secondary evidence for birth is not being submitted, then in those instances, I'm seeing that RFEs are being issued. With reference to medicals, also RFEs are being issued. And how lawsuits will help applicants stuck with RFEs and delays. You can file a writ of mandamus. A writ of mandamus compels USCIS to process the case within a reasonable period of time. So it's a lawsuit filed. It's your constitutional. It's based on constitutional law or your rights under the Constitution. And of course, this should only be done if the case is pending for maybe 2 years or 3 years, and there is no reason given by USCIS for why the case is pending, and you have followed up several times to USCIS. One significant change that has occurred under the present administration, which we didn't discuss, but which affects processing time or your ability to follow up on processing time is that they have defunded the ombudsman's office. The ombudsman was an agency, an independent agency that would follow up with USCIS whenever there were any delays. So you could actually contact the ombudsman's office and they have a whole data and they have a whole system whereby they follow up with USCIS for any cases which are over the processing time. So they have removed and defunded that ombudsman's office, so that's no longer there. So we have no ability to follow up with the ombudsman's office anymore for cases which are beyond the processing time. So now we only have the federal court to fall back on, and now that's our last line of defense with all things immigration. So whenever the administration is not doing what they're supposed to do, or they're not following the laws, definitely filing a lawsuit in federal court uh, will help, if if it's a reasonable request. The next question he had was, Gnana Mukund had, was with reference to, are RFPs being issued for wet signatures? RFPs will always be issued for wet signatures because digital signatures are never allowed uh, if you're filing a paper-based petition. If you're filing a 485, I-130, but if you're filing an I-130 online, for example, then you do not have to do a wet signature. You can sign online. But if you're filing a paper-based application, you have to file with a wet signature. It does not have to be an original signature. It can be a photocopy of your signature, but it has to be a wet signature. So you can expect, in fact, you can expect that the case will come back rather than getting RFP. They will send it back through the mailroom itself if they notice that is not a wet signature. So that's different from an RFP.
All right, I'll pick up the next question from Venkata Suvarna. What is the timeline for E1B category to move forward?
Well, EB1 category, especially for Indians, is backlogged, as you know. The rest of the world is not, but India is backlogged. And we don't expect that this year there will be any forward movement for, or at least that the EB1 will become current. Maybe there will be some forward movement, but we see that there is high demand for EB1. Since EB2 and EB3 are so backlogged, everyone is trying to qualify under EB1. It is difficult to qualify under some EB1 categories, such as extraordinary ability or researcher category, but a lot of people are trying to qualify under that category also. But it is not that difficult to qualify for EB1 multinational executive, especially if you have a company, a multinational company, and you're working in an executive position, then it's easier to qualify under EB1. And a lot of people are opting to work for multinationals so that they can qualify under EB1. So we are seeing that there is a lot of backlog for EB1 cases for Indian nationals. So if you are not an Indian national, you can expect forward movement throughout the year. But if you are an Indian national, then you might see limited forward movement or no forward movement for the rest of the year.
All right, I'll move to the next one. This is again from YouTube. And before I go and read this out, a gentle reminder for everyone joining our streaming today. You do have opportunity to drop in your question through any of the streaming platforms that you're currently consuming this webinar. And as a token of appreciation, we are giving away one complimentary early bird session with Prashanti as well, for a deeper dive into any of your questions. So if you are interested in applying for that early bird complimentary session, do feel free to leave out your email in the chat window, and someone from our team will reach out to you. Next question is from Madhur Tiwari from YouTube. Do my previous employer has to reprocess I-140 if I rejoin them? Previously, they communicated to USCIS that they are intended to revoke. Your firm has done I-140.
Okay. If they have revoked it, then yes, they have to refile it. It's possible that they might have labor proved, and there might be a problem with reusing the labor cert because a labor cert expires, and especially if it's a revoked I-140, you might have to go through the labor certification process again. But yeah, definitely, if they have withdrawn it, they'll have to go through the entire I-140 process again, and they'll have to refile the petition. If they have not revoked it, then the I-140 will still be active, and once your visa number becomes available, they will be able to file the 485. But if you're not working for them, you might want to work for them, start working for them, get on their payroll before they file the 485. Otherwise, there might be questions on whether it was a bona fide job offer or not. So that's something to think about.
All right. Uh, Prashanti, now can we move through some of the questions that we received from our website and YouTube channel?
Sure.
Okay, so questions from YouTube. What are the chances of third round of H1B in 2026?
Also, before answering the question, I just wanted to let you guys know that we also have a uh, new program, new webinar series, or a new video series, I must say, called Ask Prashanti. And in this, you can put out your question either on my website, right, Vishal,
That is
or
correct, yes.
the questions can be asked in YouTube or any of my social media, and I am answering those questions on a weekly basis in the form of in a video format. And I am, answering it by name so that you know that it's your question that's being answered. So, reach out to me if you have any questions through my social media or YouTube, and I'll be happy to answer them every week in my Ask Prashanti video series. But going back, Vishal, to the question on YouTube, are there chances of third round of H1B in 2026? I think they are. We have good chances of another round of lottery for this year, because I am noticing that, first of all, not many registrations as last year. Second, even people who got selected under the registrations, a lot of people are not filing their H1s. So USCIS might not have enough number of H1s to cover their 85,000 H1B cap, and they might end up doing another lottery. We've seen that there have been second lotteries the last few years. So I'm expecting the same again, but let's wait and see what happens. And yeah, we'll wait and see. But my feeling is that we'll have a second round of lottery.
All right. Uh, Next, YouTube user handle Manuel Meza R34 asks, has anyone gone to Mexico on a AP, stay and then travel to another country, but come back to Mexico before your AP expires to have a re-entry into the US?
AP is basically advanced parole, and that's apt for this episode because we're talking about green cards. When you file for your adjustment of status, if you're in the US, which is the final step to get your green card, you'll also file for advanced parole, um, which acts like a visa, which allows you to travel, back into the country. And if you have filed a family-based case, you have to travel on advanced parole. You cannot travel on your underlying non-immigrant status, because if you do, then your green card gets cancelled. If you're on employment based, if you're filed your green card based on employment based petition, then you have the opportunity to either use AP or you use your non-immigrant visa. So, having said that, this person is traveling to various other countries and wants to know whether they can come back on AP. Yes, whether you travel to one country or two countries, AP acts as a visa which allows you to come back into the US. The only thing you have to keep in mind is make sure that your advance parole, you're carrying your original advance parole, not a photocopy, you're carrying your 485 receipt, and also make sure that your AP is valid. and that the date has not expired. And of course, your passport is valid. So as long as all these conditions are met, you will be able to travel back on AB.
All right. Then we have a few questions from the website. Prashanti, do let me know if you want me to go through all of them or you want to cherry pick a few.
Sure. Please go through all of them.
Okay. Uh, I'm L2S and my wife is L1A. Company has applied for L1 extension in October under normal processing and they don't want to convert to premium. L2S I-94 is going to expire on May 4th. Uh, a I-539 applied in December. Uh, L1A 194 expiring on April 4th. Extension applied. Questions. Can I work from USA in this condition post May 2nd? If it's no for above question, can I go back to India and work? But being I-9 expired, is that still an option? L2S company is supportive. It's a small manufacturing company that don't have a legal team and hence wanted to know what's my best option here. Appreciate your answer.
That's a great question. And L2S is basically a spouse of L1, which is the multinational executive non-immigrant visa. And L2s are allowed to work even without an EAD, just based on the fact that they're on L2. And so you have to be on an L2 to be able to work. So if your I-94 has expired, you're not on an L2, you're on pending L2 status, and therefore you're not eligible to work until your L2 actually gets approved. So that's the first part of the question, the answer to the first part of the question. The second part is whether Raghu, can go outside the country and work from there. Yes, you can, but that's an accounting question. You have to find out from your accountant, and your company has to find out from their accountant whether they can still put you on the payroll when you're not in the country. I-9 may not be an issue because you're not in the country. So I think it becomes more a tax issue. Neither is your immigration status an issue because your immigration is only an issue. Your immigration status is only issue is if you are in the country. Otherwise, you're not subject to U.S. immigration laws. So I think it becomes more of a tax issue as to whether they can pay you in India, and if they can't, whether they can pay you in the US and how they can continue to put you on the payroll. I think the best option might be just to pay you in India, so that there's no question, definitely from an IRS point of view or USCIS point of view. So yeah, that's the answer to that.
Great, thank you. Next question is from Abhishek Prakash. I have a question regarding the H-1B filing. My company is ready to file for my H-1B, but they lack the legal support and haven't done it before. So, can I hire a legal attorney myself that can help me with the paperwork and I pay the legal fee and the company is ready to pay the government fee required with the visa filing?
So you have to keep in mind that even if you are looking for the employer, even if you are looking for the attorney, and even if you are paying the attorney, in a H1B scenario, the petitioner always is the company. So the attorney will be representing the petitioner. The signature is done by the petitioner. All that is done by the petitioner. So it's possible that the G28 is signed by the petitioner, not by you. So the attorney is really representing the petitioner because there's no other way of doing it. But of course, that should be fine. They can represent you and the petitioner as long as there's no conflict between the two of you. If there is a conflict, then the attorney has to withdraw from representing one of the parties. That's the part that the attorney has to keep in mind. With reference to legal fee, there is no issue really with you paying the attorney fee. It's just that you should not pay the USCIS fee, of course, but you can pay the premium processing fee, part of the government fee. But there's certain government fee that you cannot pay, like the ACWIA fee. But however, even the legal fee, we usually recommend that the beneficiary doesn't pay it, because USCIs might come back and say that there is no employer-employee relationship, or there is no bona fide job offer, because the employer is not paying the attorney fee for filing a petition that they are supposed to be filing, right? So that's the something to keep in mind. But there is no law which prevents you from paying the attorney fee.
All right. Next question from website is from Hong Tao Liu. I have an active H-1B visa. My employer is planning to terminate me. They have put me on a 2-month unpaid leave and formally terminate me at the end of this leave. When will my H-1B grace period begin? From the day I was placed on unpaid leave or from the date of formal termination?
So from the date that not from if you've been granted leave, then not from that date, but from the date that you are actually terminated, meaning from the last date of working, after your leave period gets over. That's when uh, your 60 days grace period will start.
All right. Next question is from Tanay Kulkarni. What if I have reasons to believe that I was not paid prevailing wage on H-1B? Is there something that can be done about this?
Yeah, that's a problem. If you are not paid the prevailing wage, there's very little that can be done after the fact. Whatever needs to be done should be done, within the first payroll. When you get your first payroll, and you have to notice whether it's, within the prevailing wage or not. I mean, the attorney can run a late payroll for you to cover that pay period, but that's not an optimal solution, because you're supposed to be paid, your pay is supposed to be prorated. That is paid, your prevailing wage has to be paid every pay cycle, not at one time in a lump sum amount. But I guess if there is no other option, that's the way to do it.
All right. Uh, Last of the questions from website is from Sanjana Alluri. I received an RFE regarding the maintenance of status for my H-1B, likely due to my role transition before the amendment was filed. My company's lawyers suggest consular processing, but given the current instability at my company, I am concerned about international travel. Are there any alternative solutions to address this issue without leaving the US? Looking forward for your advice.
Yes, so one of the issues that we have to be careful about when we're filing the H-1B under the new regulations is maintenance of status, because they're looking at this very carefully, and they're asking for documents to be submitted upfront with reference to this. So, if you are not maintaining status, what is likely to happen is that you will get a H-1B approved, but the H-1B will get approved for consular processing, and then, as you said, um, you'd have to go outside the country and get a visa. And yes, I do agree that there's extreme vetting now, and especially if you didn't maintain your status. Depending on the circumstances, of course, if the circumstances were beyond your control, maybe you could argue, or maybe you could give that reasoning to the consular officer to say that it was not intentional, or it depends on the circumstances. Again, if it was for a short period of time, maybe you can justify it. But yes, there's definitely an issue. There could be an issue at the consulate, and you may not be able to return back. So there's that danger of that happening. Is there another option you could, in your response to your RFE, instead of just giving up and asking for consular processing, respond with a non-quote request That is a request on humanitarian grounds to approve your case even though you didn't maintain status. And again, this might be approved depending on the circumstances. Again, if there was no intention to violate your status, if you're able to show that it was beyond your control, those cases are good for a nunc-pro-tunc argument.
Okay. That wraps up all the questions that we received from previously from YouTube and website. I'm going back to the live stream question from YouTube. Madhur Tiwari, to whom you've already answered. I think there's just an extension which says, they can't use previously approved PERM.
So the only instance, I was thinking about this, the only instance that you can use a previously approved PERM is if it is within the 6-month period, because a PERM expires after 6 months, or in the circumstances where you apply for the I-140 on time, but the I-140 gets denied and you're refiling using the PERM. In that situation, even if the PERM is expired, they will still consider it as timely filing. But if it is because the I-140 was withdrawn, then I don't think you can use the previously approved PERM, but I will look into it. But as far as I know, as far as I remember, you can't use the previously approved PERM in that situation.
Great. Madhur, I hope that answers, and you can always go back to the YouTube channel or our website to connect with Prashanti for a session. There are obviously a number of ways that we can assist you, whether it is your work visa requirements, travel visa, green card, investor visa, amongst other applications that we can support you with. As I mentioned earlier, Prashanti comes with over 25 years of experience, and we have client reviews across social media, across the website, and on Google as well, that would give you a good testimony of the kind of work that we've done for some of our clients. So you are in safe hands. And finally, as I mentioned, we are giving away one early bird complimentary session today. So if you would like to have that early bird complimentary session from Prashanti, feel free to reach out to us. Either email Prashanti directly at prashanti@readyesq.com, or drop us your email in the chat box, and someone from our team will be happy to reach out to you. To recap, as Prashanti mentioned, that we do this on a monthly basis, the webinar series. So we will be announcing the date and the topic for the next webinar very soon. And if you have any suggestions on what you would like us to cover in the next webinar, do reach out to us. We are available on all major social media channels. You can go directly to our website and send us a form submission, and we would be happy to take in your questions and or your suggestions for the next webinar topic. And Prashanti is now even more accessible through weekly video series called Ask Prashanti. So if you have any questions, Prashanti would be taking selected questions. So my recommendation is, if you want Prashanti to take up your question, do reach out to us through a number of ways, through social platforms and or the website, or even email. And we would be happy to take in any of your questions. Prashanti, thank you so very much for your time. Did I miss out on anything? You'd like to add anything here as a closing statement?
I think we're good. You covered everything, and I think we covered a lot during the session, and we had a lot of interesting questions which we were able to answer as well. So I can't wait to see you guys again next month. Please do sign in, register for our webinar series, because we cover interesting topics and we answer a lot of your burning questions.
All right. On that note, I will end today's stream. Thank you so much for joining in today. As I was about to end the session, I think there is a question coming in, Prashanti, and we still have a minute or two, so I may well just give this opportunity. So this question, it's just a statement, I guess, at this point in time, or just a note from YouTube user Meljo George, F4 2007 India. I guess there's more information that we would need.
Right. I mean, right now, India, they're working on 2006 December for dates for filing. So you have a ways to go.
All right. Okay, so yeah, Meljo George, if you have any further questions, comments on that, feel free to reach out to us. Okay, thank you so very much for your time today, Prashanti, and thank you so much, everyone, for joining today's session. We look forward to seeing you in the next one.